As a general rule, attorney-client privilege shields from disclosure any confidential communication between an attorney and his or her client. That communication has to be for the purpose of eliciting or obtaining legal advice in connection with any matter at all in connection with that professional relationship. The attorney-client privilege exists at a constitutional level to ensure that people seeking legal advice are able to disclose anything they want to an attorney without fear of that information being disclosed or used against them at a later date. All warrants issued by courts in the state of New York and in the federal government require constitutional protections. In New York, Criminal Procedure Law 700 in all of its subsections create a vast regulatory scheme for ensuring the constitutionality of all wiretaps. When it comes to attorney-client privileged information, there's an obligation for the state and its investigators and all the people involved in the issuance and recording of information by way of wiretaps to minimize conversations that implicate the attorney-client privilege. Once a government agency becomes aware of an attorney being recorded, there's an ongoing obligation both to notify the court and to minimize those calls to the extent necessary. The court often gives minimizing instructions specific to attorneys that they know are being recorded in connection with an ongoing wiretap. In general, wiretaps are good for a period of up to 30 days in the state of New York. The government agencies will go back to the issuing judge who issued the warrant and request extensions or amendments and extensions of those wiretaps. Frequently, where there's communication that's been minimized between attorneys and clients, the either district attorney's office or attorney general's office who's seeking the extension of the warrant will bring to the court's attention the fact that there are attorneys whose numbers or conversations are being picked up on these warrants. Frequently, the judge will give specific instructions as to how to deal with those particular calls. And what you'll often see is a requirement that the government agents who are in the recording rooms notify the supervising assistant district attorney immediately in order to determine whether or not it's a call that should be minimized or a call that falls within some exception. The importance of this piece is the exception, which is that when it comes to attorney-client communications, any communication where the attorney is acting or giving advice in furtherance of a fraud or advice relating to the commission of a future crime, that is not subject to the attorney-client privilege. That is an exception that's referred to as the crime fraud exception, where you have an ongoing relationship between a client and an attorney that is the subject of an investigation by law enforcement. There's still an obligation to potentially minimize privileged calls where it is not communication in furtherance of a crime or advice given in furtherance of a fraud, but rather actual attorney-client privileged information concerning other matters, for example. I've had several instances where clients or attorney clients had communications intercepted by the federal or state government. One particular case of interest involves an attorney in New York who we represented in connection with a felony indictment issued by a local district attorney's office. That matter involved an attorney who represented a group of young businessmen who bought and sold real estate and bought and sold automobiles. The attorney was initially engaged to represent these young people in business transactions. Over the course of 18 to 24 months, the attorney would on occasion receive calls to represent some of these people at arraignments where they had been arrested in connection with receiving stolen property or unauthorized use of credit cards. And it became evident to the attorney at some point that this group of young individuals was engaged not just in these two legitimate businesses, but also a third, fairly broad, illegal scheme involving stolen credit card information and theft from high-end stores. At some point in time, a local district attorney's office, with the assistance of the local police department, obtained wiretap warrants to listen to and record phone conversations between 2 or 3 of the leaders of this group. And in the course of those conversations, it became apparent to law enforcement that some of these conversations were being had between the principals and our client, the attorney. This information was brought to the warrant judge who issued the warrant in the first instance, and a specific instruction was given that in the event the monitoring room determines that a call is being made between the client and the attorney, they are to immediately notify the supervising assistant district attorney, immediately, 365 days a year, 24 hours a day, was the language that was contained in the amended warrant. Over the course of the next 18 months, between 300 and 500 communications were intercepted by law enforcement between one of these two principals and our attorney-client. Of those 300 to 500 communications, only 33 times was the assistant district attorney in charge notified. And ultimately, the evidence which supported the indictment of the client was based entirely on the communication that had been intercepted. When the case was first presented to me, it appeared to be a gross violation of the rule concerning attorney-client communication. I was able to read the transcripts of all of the intercepted phone calls. I was able to read all of the intercepted text messages. And there were hundreds of communications concerning bail hearings, suppression motions, potential plea deals, transactional representation on buying and selling car vehicles. And all of this information, which appeared to be clear on its face to be attorney-client privileged, had escaped detection and run through the protections put into the minimization orders in connection with the wiretap. As a result of this, we filed a motion to suppress the evidence collected through these wiretaps as they related to our client, who was the attorney. A very naive part of me thought that the government might in fact concede to this and agree that the government had in fact overstepped its bounds and intercepted clear attorney-client communication, the result of which would be that all of the communication would be suppressed and there would be no evidence left upon which to prosecute the case against our client. As with all motions to suppress, or most motions to suppress, they result in an evidentiary hearing before the court. And in this case, the witness was the supervising assistant district attorney in charge of that particular warrant. By the time we got to the hearing on the motion to suppress, this individual had become the deputy chief of that particular county district attorney's office and was a very influential and talented lawyer, which made for an interesting few days for me. But ultimately, in the course of the cross-examination of the assistant district attorney, it was acknowledged that the limiting instructions were not followed to the letter of the law. The assistant supervising district attorney acknowledged that hundreds and hundreds of times, the monitoring detectives would know that it was the attorney who was on the line, and they didn't minimize the calls, nor did they notify the supervising DA, despite the instructions in the warrant that required it. Not only required it, but required it immediately 365 days a year, 24 hours a day. At the conclusion of the hearing, I was happy, the client was happy. I fully expected the court to grant my motion, suppress all the evidence, and dismiss the case. But to the contrary, the court found that indeed the monitoring detectives had failed to adhere to the limiting instructions, but that a fair number of the communications were subject to the crime fraud exception and should not be excluded. And therefore, the motion was denied with respect to suppressing the evidence as a whole, because in general, the government complied with the general directives of the search warrant. My client was devastated. I was shocked. The bright side was that we filed a notice of appeal. I expected to win on appeal, but the result of the evidentiary hearing, in playing all of these tapes and seeing most of these texts, was that both the court and the district attorneys involved in the case came to recognize that the attorney-client was really not conspiring with this group of people to commit these crimes, but was rather, in fact, really just representing them in connection with the crimes that had already taken place. And as a result, we were able to obtain a misdemeanor plea for receiving stolen property. As a result of that, we gave notice to the grievance committee. A hearing was held. The attorney was not disbarred, and they were permitted to continuing to go on with their life and continuing to practice. What surprised me most about this case was really the dichotomy between my understanding of what the attorney-client privilege represented and how strictly it must be construed, to the way that the court and the government dealt with attorney-client privilege once we got into court. I've been an attorney for 28 years. My father's been an attorney for 68 years. And it was always my belief that attorney-client privilege was essentially sacrosanct. And it was something that you held close, and that the Constitution of the United States and the individual constitutions of the particular states protected against any type of infringement on that attorney-client relationship and communications that exist pursuant to it. One of the seminal cases in New York is known as People versus Winograd, and it says that strict compliance of a warrant is necessary to ensure constitutional protections, especially when it comes to attorney-client privilege. That, to me, is consistent with my understanding of that sacrosanct relationship between an attorney and their client, that nobody can pierce that, and that it should be held close, and that all clients should feel confident that anything they tell their attorney and the advice that the attorney is giving them is subject to those constitutional protections. The law in New York is codified by Criminal Procedure Law 700, says that the strict compliance is required, and the burden is on the government to show strict compliance with the terms and instructions of a particular warrant. My experience in this case was very different. And even though the language in the order and the language in the law says that the burden is on the government, what I found was that the burden was on the defense. The burden was on the attorney claiming that privilege. The result of the motion was consistent with that, even though it was plain as day that hundreds of protected attorney-client privilege communications were intercepted, were read, and were disseminated amongst law enforcement and the court. The shock that I felt reading it was not felt by the government. It was not felt by the court, and it wasn't reflected in those rulings. That was the pure dichotomy of my understanding of attorney-client privilege with the way that it was treated in a criminal court and by that local prosecutor's office.